Thank you for joining this episode of our webinar series on best practices in e-discovery. Today's session is focused on how to use data mapping to get the most out of your custodian interviews, identify evidence, and build your case. My name is Jeff Fugit. I'm Vice President of Sales and Marketing for Lexby, and I'll be the moderator for today's event. Our webinars take place monthly and cover a variety of relevant e-discovery topics, trends, best practices, and strategies. Space is limited to the capacity of our webinar platform, and with the popularity of these sessions, I highly recommend registering promptly when you get the invite in your inbox. If you have technical issues or questions, please email us at webinars@lexby.com and we'll address those right away. Our webinars are available online at lexby.com for viewing via streaming video or downloadable as a PDF presentation or MP3 podcast. You'll find this webinar and a complete listing of other webinars at lexby.com. To be notified of future live and on-demand events, please email us at webinars@lexby.com or follow us on LinkedIn. So a little bit about Lexby. Based in Austin, Texas, we provide a very affordable cloud-based e-discovery platform and services. We really specialize in equipping the boutique firm with an e-discovery solution that gives them full control over the e-discovery process, DIY capabilities, and incredibly fast performance. We're the industry's most affordable and full-featured DIY e-discovery platform. We're the industry's fastest e-discovery processing and document review platform. We deliver the industry's fastest return on investment as recognized by G2 Crowd in a study that was done last year. We've got a team of experienced e-discovery specialists and expert consultants who are all ACED certified and ready to help clients on a moment's notice should they need it. If you'd like a demonstration of our platform, simply email us at sales@lexby.com and we'll get that scheduled for you. Our guest speaker today is Gene Albert. He is the CEO of Lexby and a sought-after speaker and author on e-discovery and legal technology. He's on the Planning Committee, Electronic Discovery Institute at the State Bar of Texas, and he's an e-discovery consultant and expert. He has a BA and MBA from UT and a JD from SMU. Before I turn it over to Gene, I'm going to share with you some insight into the shifting ESI landscape and some of the critical considerations when starting the process of preparing for your custodian interviews. Really, this is as good a time as any to discuss the IT and ESI landscape since we're fresh off the Consumer Electronics Show that showcased all the latest and greatest connected devices and sources of ESI. Understanding the IT and ESI profiles of your custodians is critical for successful interviews. I'm going to cover some of the key categories and utilization statistics that can help you craft your custodian interview strategy. It is important to start with a holistic approach, and therefore I'm going to cover some IT utilization and consumption trends by demographic. Many litigators rely heavily on email, and email is critical and will continue to be so for the foreseeable future. However, there are shifts in IT consumption, and the proliferation of alternative communication modalities and emerging sources of ESI are critical and really shouldn't be overlooked. So I'm going to touch on some of those as well. We frequently cover the growth in data, and it shouldn't surprise anyone that by 2025 we'll have eclipsed 160 zettabytes of data, and it's growing exponentially. Not only can the growth in data be challenging, but the fragmentation of ESI sources and emergence of new sources can often leave evidence obfuscated. On this slide, you'll see in the US alone, there will be almost 1 billion mobile connected devices by 2020. The mobile ecosystem and app economy is a huge source of ESI. I've seen mobile device and data governance policies for Fortune 500 companies that prevent the use of mobile devices in restricted areas in order to mitigate IP theft. In corporations, the iPhone was really the genesis and the main driver behind Bring Your Own Device, or BYOD, which is a common acronym that I'm sure you've heard. And this movement, which has caused a whole host of issues from shadow IT, and we'll talk a little bit more about that, and nefarious acts with cameras to data loss. These devices have made data portability extremely easy. So it's super easy to move data around, and so that has caused issues. So gaining an understanding of the mobile devices utilized by the custodians is an important step. How many and what kind of corporate liable and individual liable devices do they own and utilize, and what is the application mix? So are all things that need to be considered. Cloud storage utilization varies greatly by age group. And this is important because you'll want to understand the profile of your custodians and the likelihood that they'll be utilizing cloud storage as a repository for ESI. On the last slide, we talked about the growth in mobile connected devices. Well, every mobile connected device that is subscribed to on a wireless carrier plan has access to cloud storage. So all the wireless carriers provide those services. And then there, of course, there are all the third parties like Dropbox and Box, as well as iCloud and Google's cloud storage. Cloud storage is cheap. Cloud storage is very easy to access and highly utilized by millennials and post-millennials. Therefore, understanding the IT utilization or consumption profile for the demographics of the custodian can greatly help facilitate the identification of critical ESI sources. This next slide covers group chat and instant messaging. So group chat and instant messaging is not only on the rise, but there are many apps, including social media, that have this capability integrated into their platforms. In addition, most corporate collaboration platforms like Slack have added this capability. So as you can see, there's a significant variation in usage of instant messaging. Millennials and post-millennials prefer chat to email, and we anticipate utilization for those demographic groups to continue to rise. And on this slide, you'll see there are several billion monthly active users that are utilizing instant messaging apps. These can be important sources of evidence. Many of these platforms export their messages in flat files or a file type that's called JSON. Essentially, it's a container file, a JavaScript container file. And at Lexby, we've got an Instant Messaging Plus service that provides you with a high utility view of these messages when you're conducting your document review. But it's important to understand the custodians and whether or not they're using group chat or instant messaging, and what their propensity to do that and how likely there's going to be evidence in those communications. If you're working in labor and employment or IP, you want to make sure you have an understanding of the adoption of collaboration apps in the enterprise. It is a fast-growing category of apps that facilitate communication, including chat and group chat, and help enterprises increase their speed to market and efficiently manage projects and resources. So some of the leading applications are Slack, Microsoft Teams, Cisco Jabber, Google Hangouts, Yammer, SharePoint, Atlassian Stride, Workplace by Facebook, and Cisco WebEx Teams. IP litigators that I've worked with have indicated on several occasions that there are incredibly valuable sources of evidence in these communication streams. So employees are often less guarded in their communications on these platforms. I don't know, maybe it's inherently the type of communication going back and forth is more informal than formal, and they feel like it's a secure and safe place to communicate. If a custodian is a product manager and they use Slack, then you'll definitely want to make sure that, depending on the matter, that as you're interviewing them, that you bring up these collaboration platforms in the enterprise and make sure that you identify those as a potential source of ESI for your matter. And then the last thing I wanted to discuss before I turn it over to Gene is the impact of IoT, or the Internet of Things, in mobile devices that automatically generate ESI. Depending on the nature of your matter, you might want to consider these sources of ESI. Not only are there more than 50 million Amazon Echo devices in market, but the capabilities of the AI platform continue to expand and continue to store billions of records. There have been several criminal cases to date where Amazon has turned over relevant records. In addition, most modern mobile devices have location-based services that store location data. And there has been a huge proliferation of video and audio files from these devices. This is another source of ESI that's growing exponentially. I'm just glad we engineered the Lexby eDiscovery platform to be infinitely scalable in the cloud to address the growth in ESI and the static, if not shrinking, time frame that the courts have placed on these matters. So in addition to understanding the composition, quality, and character of custodians, you'll also want to have an idea of their technology profile and utilization in order to ensure you're not overlooking a critical source of ESI. Before I turn it over to Gene to get into the details of the custodian interview and data mapping process, I wanted to ask for your participation in some polling questions to help set the stage for today's presentation. Our first polling question is, what is the average number of custodians for your cases involving e-discovery? Is it 1 to 5, 6 to 10, 11 to 15, or 16 plus? And while you're answering that, I'll take this time to thank you for participating in our polling questions today. All right, I'll go ahead and close out that poll. And our next polling question, do you use data mapping during your custodian interviews? Yes, no, or what is data mapping? And if your answer is number 3, what is data mapping? After today's session, you'll be able to utilize data mapping during your custodian interviews. All right, I'll go ahead and close out that poll. And without further ado, I'll turn it over to Gene Albert. Gene?
Hi, I'm Gene Albert, CEO of Lexby, and welcome to our discussion today on custodian interviews and data mapping. This is a very pragmatic subject, and we're going to talk about discovery workflow and case development, custodians, why interview them, how to do them, forms, etc. Benefits of, and then data mapping, how does that tie in with custodians, benefits of it, reports, logging, how to integrate that into your e-discovery system, and then conclude on some takeaways. I have a lot of materials here. I talk pretty fast sometimes. We'll have copies of this webinar and recording, and also the forms referenced in here will be available for participants. The next slide here goes over the e-discovery workflow. And this shows up in the blue, the main stages of the case, and then down in orange are various subparts or tasks that are done or functions. The main things we'll be talking about here will be custodian identification on the left and data mapping as part of the setup and planning. This goes into collection as well. We have other webinars that cover these other subjects if you're interested in any of these things specifically. First question we should address is just how do you identify custodians? What are they? This isn't very well defined in or consistently defined in case law and rules particularly, and a lot of this has grown up through discovery practice. So first, who are custodians? These are individuals who possess data or electronically stored information, ESI, documents that are potentially relevant to the case and from whom data should be collected. These are people that have knowledge of facts related to the litigation or dispute. There are several types of custodians we refer to. One is key custodians. These are the individual parties, the deponents, witnesses, subpoena subjects. These are individuals that have relevant knowledge and documents about the case or dispute matter. The second are departmental custodians. These are individuals who are responsible for the departments and documents in them, even though they may not have personal knowledge of the specific document in question. So the HR department in larger companies may have a custodian in charge of HR documents that would respond to a subpoena or a request for collection of documents and be the custodian for those documents. There's also the concept of representative custodians. In larger cases, it may be impractical to collect the data from everyone of a class and to develop whatever the theory of the case is, or to get representative data, one or more representative custodians might be selected. So if a large company had 100 salespeople and there was some issue having to do with the salespeople, one or several salespeople might be identified, and then they would be a representative custodian for the class of persons, even whether it's a class action or not, but for the group of individuals for collecting data for them to develop the theory. Another thing I want to mention is the idea of shares. So sometimes some data, there really isn't anybody who had control of it particularly. This could be a network drive or a cloud drive for individuals or department or a company in general. And sometimes data will be collected from those shared drives or shared repositories, and the custodian will be identified as a share for those for that purposes. I want to give an example email that I think illustrates well what the custodian concept really is. So imagine a January 1, 19 email from Bob to Sally, and this is represented by an Outlook MSG file, that being MSG being the file format that Microsoft Outlook keeps emails in, and that includes both the email body, metadata, and the attachments, and it's represented by a single MSG file that can be taken out of Outlook and copied individually. This MSG was in Bob, as you'd expect, and also Jim's possession, who wasn't a part of the email, but not Sally. So in this instance, you have an email going from Bob to Sally. Bob has it, Sally doesn't anymore, and Jim does. So why does Sally not have it? Well, it could be deleted, any number of reasons. Maybe it wasn't delivered to her. Why does Jim have it when he wasn't a party to it? Who knows? That could be developed. But in this case, Bob and Jim would be the custodians for the data, and Sally would not be. People often think that the sender and receiver are automatically custodians of data, but that's not the emails. But that's not the case. The custodian is a possession concept, and it's orthogonal to whether somebody sent or received, although it's highly related or correlated, of course, in most cases. Next slide, we'll talk about why interview custodians. Lots of good reasons to do it. Locate the relevant ESI. You build your preservation obligations and legal hold obligations from the custodians to meet the Zubilaki requirements or obligations. I'll talk about that in the next slide. And another reason is to address, have somebody talk to the custodians early on and address possible anxiety. Many people, when they receive a legal hold notice, if they're not used to it, can become very anxious about it and can spin. So it's an opportunity to talk to them, control the narrative, explain the process, answer their questions early on. Another key reason is to gather facts and do your initial case assessment. As cases have gotten larger and larger, it's harder and harder to understand all the key documents early on in a case, and more dangerous to wait as the case develops. So anything one can do early on to start building one's narrative, one's story, do timelining, and have a consistent theory of case early is very important, and that can be done very well with early custodian interviews. From the custodians, if done properly, you'll identify the data stores and allow for data mapping of the available ESI in a case, and we'll talk about that later, as I won't address it here. Prepare for collection of the ESI. Plan ahead for discovery obligations. How long is it going to take? How many custodians? What can be committed to? What's it going to cost? All these can be fleshed out with the beginning stages of good custodian interviews, and prepare for meet and confer and other discovery obligations as one goes in. So I'd put this all under the general category of GIGO, garbage in, garbage out. As you're building up your case, if you don't do a good job at this on the front end with a complex case, it's going to be very difficult to go back and get to the same level otherwise if you try to pick it up at a later time. The next slide will talk about the Zubilaki obligations, a very famous series of cases that are the basis for modern e-discovery law, certainly at the federal level and a lot of the state levels, and has been the ideas have been integrated into the rules, but it's good to go back and read the original case and understand where it was coming from and what the reason was. From the Zubilaki obligations, we get the litigation hold when the duty arises, when litigation is reasonably anticipated, that hold should be issued. Obligation to interview data custodians, etc. The basis for this is the attorney's obligation to the court, and in Zubilaki, the court was saying that it's not possible for the attorney to disclaim any of this not being done properly, and that there's an affirmative duty on the attorney to make sure that this happens. So that was the thinking of that, and that's carried over to the day. All of these Zubolecki obligations, discovery obligations are difficult or impossible to do well if the custodians, case participants aren't adequately identified and data interviews from them early in the process. So what are the downsides? The next slide of not interviewing early and completely. I think we talked about most of these before. Conflicts can come up later. You may not identify that you had a conflict, and that can come up with early custodian interviews and really understanding who all the parties are and what the relations are. And that can give one more time to mitigate any conflict issues that have come up through waivers or whatever. Also, the errors in depots not caused by timelining. What I mean there is that it helps you develop your theory of case early on and mitigates getting into one's depots and having to change theory of case, which is always a problem and can allow you not to be able to develop the evidence and have a consistent theory as you come out of discovery. Why is this done poorly sometimes? Well, a lot of reasons. One is with larger cases, there's more electronically stored information, more documents, and there's just more to do there. The cases can be more complicated with many case participants and potential custodians. There can be international custodians, and that can raise a number of issues of how to effectively interview them and do one's preservation and collection. If there's ever a change in case representation, this can be an issue too, that some of this can just fall between the cracks if it happens early in the case, or it may have been done improperly or with the prior counsel, and the subsequent counsel has to go back and try to backfill and handle things that could have been done earlier. Improper delegation to persons that are not adequately trained or have the skills to be able to do the custodian interviews, and just not having a good system, even with competent people. If you're not using checklists and good forms and a system, it's easy to make mistakes and have things fall between the cracks. Next, let's jump into the custodian interview forms. I'll go through these pretty quickly because we've got these at the end that you can download them if you want to, but just go over the type of information. So one would be a record of custodians form, where you would start to put together just who are the custodians who you think have information, and this will go into data mapping. As usual, we use Enron data because that's publicly available in a complex commercial case, showing things like the range of the events, when the hold was issued, etc. This ties into what we have in the platform that would be the cast, you could call the cast of characters. So we start to try to flesh out the relationships between the individuals and the entities here that are involved. In some litigation, this is very simple, but in some litigation, it's exceedingly complex, and half the job of understanding the case is just teasing out the different relationships between all the parties and entities, etc. So having a system of starting to put this together, identify who they are, and then tie that back into the documents in your fact timelining is very important. What approaches can one take to custodian interviews? Well, there are several. One is more of a conversational approach. So these would be one-on-one meetings, allows for a lot of reassurance and questions and clarity, information gathering. The disadvantage of it, is that it can just be very time consuming for large organizations, and you might have inconsistency in approach between how it was handled. Another is more of a formalized approach where it's off of a checklist or a specific questionnaire, but it's done. It's interviewer driven. Certainly a highly defensible way of doing it, but can be too formal and require modification on the fly to sort of fall out whatever comes up from the interview, of course. Third approach is a survey approach, where the custodians would fill out a form without a dialogue. Much faster, much easier to do without sit-down interviews. and it's certainly more cost effective. The trade-off is it's impartial and should be followed up on to make sure that the information that it was gotten properly, and that it misses out on the opportunity for one-on-one interaction, et cetera. And any given case could have a combination of these approaches for different custodians, of course. Next, let's get into a custodian interview form. Our suggestion is that whenever possible, that an actual interview be done in person or on form by a knowledgeable interviewer, and then the information filled into a form rather than sending it out to the custodian themselves on it. And this form is set up with that assumption in mind. So this would be a per custodian form. Start off with relevant information if when the hold is issued, etc. The next slide would get various background from the custodian to understand where their role, if they had inherited any files or if it was all prepared for them, what their job was, etc. Next would be email information. It's amazing how many emails people have, even in business relations. Some companies are very strict about custodians only using their company email address or addresses for communications, but in others, there's a lot of overlap between company and individual emails, and that should be ferreted out, and then collections may need to be done from individual email accounts if that's the case, if there's potential responsive information there. Location of files, so this is used to build up the data stores. How many people have a lot of different devices, how many computers they're using, are they using portable drives, do they have information at home, is it cloud, et cetera, et cetera. This next slide is showing more of that, many of the different places where data could be stored. Recently, more and more companies are going to cloud, so often companies will have one or more cloud places that employees are keeping information now. Next slide talks about social media was company information used in either a company-sponsored or other IM or social media accounts of any type. So the main ones are identified there and should ask if any potential information is there where a collection might need to be done. One of the questions talked about shares, personal folders, has any of this been moved, external drives, flash, etc. Next slide, going voicemails, calendar entries, an open question of any other information that could be helpful, names of contacts of other people that might know about the case. That's going back to just developing out your cast of characters and where the data might be. At the end of the custodian interview form, this includes some cautions to the custodian not to delete or destroy anything. This could be a reinforcement of the hold and the seriousness of this, making sure that we get everything in. And then lastly, on our form, we've got a place for the interviewer to identify who he or she is, and that could be the attorney, could be somebody on the attorney's staff, could be somebody on the e-discovery provider staff, or somebody else who's brought in to do the interviews under the direction of the attorney. And then this form would be signed by the interviewer and would serve as evidence that a proper attempt of getting custodian information was done, and should be good evidence for the attorney meeting his or her Zubileki obligations, and as that's codified in various e-discovery rules in federal and state courts. The forms you were just looking at are available on our website and our help. So you can give you instructions on how to go over there and get to our help section and download the form that's on a help page, and then you can see the form is on the bottom of the page that you can download. Next, let's turn and talk about data mapping. This flows as the next step to do after or concurrent with doing the custodian interviews. So the data mapping is an organized map of data sources for legal purposes to be able to identify how many legal stores do the custodians have. They will almost always have multiple, sometimes many different data stores, what type and how much data is in these data stores, and has that been preserved. And this will come out in a series of different reports. And this is used as the basis for the rest of discovery to determine what there is to discover and how to preserve and collect it. This should be done, of course, for one's own side of the case and the custodians under one's control, but it can and perhaps many times should be done as best as possible for opposition. Getting a data map, even if it's tentative and there's a lot of holes in it, helps of the opposition helps on understanding where their data is and what you should be asking and who's doing what, and have preservation and collection obligations been met. It's very ad hoc to do it without some systemized way of building up what data they have. This can be attempted to be gotten once one's in depositions, of course, but if you wait till that long and proper preservation wasn't done, then you might have a complaint for that might be listened to, but the data might be lost if it wasn't preserved and collected properly. So that could end up hurting the case if not enough comes out of the sanctions. I want to talk first about what data mapping is not. If you go to a client and ask for a data map, or you try to build this up and you talk to IT people, they'll think in terms of a network map, which will be just a connection of all the computers, is often done with the tools that are built into the network analyzers, or it could be done ad hoc in Visio or PowerPoint or a number of different tools. So you'll see something like this, and it can take a while to get some of this. So these are kept up to date. Not very often, so they may have to go back and develop it. So you can lose a lot of time trying to get this out of the client and then end up with something that looks like this, but that is practically useless for purposes of having a legal data map that I'm talking about in this webinar. Benefits of data mapping, number of ones other than that we've talked about before. Risk of missing data sources that you could have gotten to with proper interviewing and data mapping. Certainly budgeting for understanding how much discovery is going to, the discovery costs are very much related to the amount of the number of people and the amount of data being collected, number of data sources, and will scale pretty linearly with that. So understanding how much data there is, how many people, how many stores goes a long way on allowing you to budget out your e-discovery and not have unhappy surprises about it, and also helping you with your timing of collection, of being able to collect as needed at various commitments that you've made to as part of the case. This, I'm going to jump into tools that we've developed here. There's other data mapping tools out there, but we use ours, for example. But you have the general ideas of this, and this could be developed themselves. We have tools for it. There's other ones out there. But the general function should be done in all, consistently in all of this. So first there'll be a data mapping log, and let me walk through this in a little bit more detail than I've done on some of these other slides. First off, you'd have the custodian and the organization and department they're in there, and information about them. And you'll see that they're repeated. So Bob Smith is repeated 3 times on this. This is because Bob Smith has 3 different data sources associated with him. So if you go to one of the far right columns there, you'll see that he has Outlook email, text messaging on an iPhone, and LinkedIn messages, all relevant to this case. And then there's an estimation of the number of gigabytes in each one of those. That's helpful in getting a budget if needed. Then whether this has been confirmed or is just estimated here on the data, if this has been looked at yet. And then there's you see a breakout of the record in between where this would be entered. So you would go through and set this up on each custodian, developing out of the custodian interviews. There would be a question to the custodian of how many data stores he or she has. Could be 1 or 2, could be a dozen. Could include cloud, in any of the sources that are out there, Skype. They would all be individual data sources. Then these would be mapped out on a record by record, row by row basis in a form as we have here, and then you can get the status of if it's been confirmed, collected, and then you can build your reports out of that. And then the next slide shows some of the reports that can be gotten out of that once it's set up. So once you've you've done all that collection, then you can start rolling these up with pivot tables and charts, et cetera, to sort of see just how much is out there. So you can see the gigabytes per custodian. You can see the, by data source, how much are you getting, going across custodian, how much has been collected, how much is confirmed, how much is unknown at this point, and then graphs going off all of that. This helps on your case be able to show that you've done an adequate job of collection. Holes in the collection will pop up when you do this. You'll just see anomalies between what you would expect. One custodian has hardly any information. Somebody similar situation has a lot. There can be reports by date range, and you can see there might have been holes from changing over data systems or whatever reason that there were problems in collection. So this is a good quality control system of being able to go through on your collections and make sure that you can be reasonably comfortable that you've put out holds preservations and collected all the data that you ought to collect, and then be able to defend it if there's any question that it wasn't done properly. Even if it wasn't done completely perfectly, that's not the goal. The goal is to do it defensively, because perfection just isn't going to be possible in this sort of thing, because it's too complicated and there's too many externalities. So one can show that a good faith effort has been done to defensively identify and collect all the information. And a system like this can go a long way on defending any criticisms that one could have of their own identification, preservation, and collection efforts. Flipping that over to the other side, something like this can be built up for opposition and can start to show the holes on how data has been collected on opposition's point. And if they've done a sloppy or intentionally bad effort to collect and to hide information, it can start popping off the screen here on these reports, when you can see what's been collected by date, what's been collected by custodian, what's been collected by data type. And this is a sort of evidence that a judge wants to see to be able to issue sanctions and allow for additional discovery, to see that one's complaints about opposition's production is not merely something that's made up or a fishing expedition, but there's a lot of meat behind the complaint. So these sort of reports go a long way on proving up your efforts to get additional discovery or criticize the discovery of opposition when it's been done inadequately. This next slide shows that the information can be tied in with your e-discovery platform. So here this data mapping log is being uploaded into our platform, LEP, which is LexB Discovery Platform, and the information about custodian and the data and stuff can be brought into the system, so you can access it consistently with your e-discovery platform, if that's helpful, which I think it often is for developing timelining and other things that are being done as part of discovery. Next, and finishing up, we're going to do a recap on data mapping. Why would you want to do that? First is to identify potential data sources found through custodian interviews, visualize the data statistics that come out. It's helpful for planning and budgeting timelining, and then it can be integrated into whatever e-discovery platform you're using as well, along with some of the other things we talked about. You can find more about this on our website. Again, this is discussed in our help with examples, and there are instructions on how to go to our website and find data mapping information that we have that ties in with this webinar and discussion. And now I'm ready to finish up here and just do a summary and takeaways on the whys and hows of effective custodian interviews and ESI data mapping. Takeaways. Big picture, have a systematic plan of attack of what you're going to do. Do it early and have resources to update it as needed. This stuff can seem mundane, but it's actually very, very strategic, on a number of ways. So it should be done, and the people doing it should have their idea on the strategic goals and values of case development and overall budgeting and getting the information one needs for their case. Use forms and checklists, ours or somebody else's or ones of your own making. This is very difficult to do if it's done on an ad hoc basis. Don't improperly delegate. People doing this need to be experienced. They need to be trained to do it properly. And a lot of mistakes can be done even with well-intentioned people. Lastly, it helps us watch out for the unknown unknowns. This is a famous quote from Department of Defense Secretary Donald Rumsfeld. In 2002, I'll do a short version of his quote. He said there are the known knowns, the things we know. There are the known unknowns. Those are some of the things we do not know, but we know we don't know them. And there are the unknown unknowns. They're the ones that we don't know. And those are the ones that tend to be difficult and dangerous. Taking this over to e-discovery, I think the unknown unknowns are the problems that often bite people in large, complex e-discovery, and that effective custodian identification, interviewing, and data mapping can go a long way on ferreting out the sort of things that could be unknowns and identifying and eliminating them through the process. So that's it for today. Thanks for attending. We've got a short survey at the end that just takes a couple minutes, and our email addresses are going to be available as well. So if you have any questions about this or have any comments, please send them to us and send them to me. We're always looking at ways to improve this and meet your needs for what you'd like to see in this type of program. Thanks a lot for attending. Bye-bye.
Gene, that was a great presentation on how to apply data mapping to custodian interviews as well as best practices. I'm going to briefly cover the LexB solution. We help organizations keep e-discovery in-house without the burden of expensive infrastructure and software. We equip you with big law technology for a fraction of the cost. We've engineered our cloud-based e-discovery platform to be infinitely scalable. And while this example demonstrates a larger matter with 1 terabyte of ESI, because we're highly affordable, I often speak to paralegals who have said LexB is a lifesaver because trying to review a matter in a PDF reader, even a few hundred documents, is a big burden, and LexB eliminates that issue. From a security standpoint, we also have the industry's best safeguards with a highly secured cloud infrastructure deployment at Amazon Web Services. Everything is encrypted and systems are always up to date. LexB is also feature-rich. We equip you with a full-featured DIY solution that enables you to handle more cases in-house. We have lightning-fast processing. We are fully DIY-enabled, which was the reason we were rated as the best e-discovery platform for return on investment. We have the Uber Index, which I'll briefly touch on as well. We have machine translation for international matters. We have integrated messaging for matters involving chat and instant messaging ESI. And we have fully integrated advanced technologies, including Neardupe and TAR, so you don't have to cobble together several point solutions. So briefly about our Uber Index. Our Uber Index is important because there's several use cases where you could miss evidence if you don't have an Uber Index. So we extract all the native characters and OCR all the documents and pull in all the OCR characters. We OCR all the images and also include translated characters, and all of that's concatenated in a single index. That way you'll have the largest searchable data set that includes hidden characters from Excel spreadsheets, that includes characters from PowerPoint notes, that includes document revision characters, and much more. So there's a bunch of use cases like that where you could potentially miss evidence if you don't take the steps of incorporating all the native characters and the OCR characters together. Next, we're highly affordable. So we have no user fees, no case fees, a free onboarding training. We have a free paralegal training program for clients, and month-to-month plans start as little as $25 per month per gig. Subscription plans include the advanced solutions as well. Lastly, we have a fantastic professional services team made up of former litigation paralegals that are all ACET certified and highly adept on the LexB platform, and they're ready to assist with custodian interviews, data mapping projects, or any e-discovery related needs that you may have. And with that, I'll go ahead and ask our last polling question, and that is, would you like a demonstration of the LexB e-discovery platform? And while you're answering that, I'll thank you for attending today's session. We'll be making the following available to webinar attendees. You can access a recorded streaming version. You can download an MP3 podcast as well as a PDF. Please let us know if you have any questions or comments about this webinar or suggestions for future topics. This webinar is part of our LexB eDiscovery webinar series, and for notices of future live and on-demand webinars, as part of the series, please email us at webinars@lexb.com or follow us on LinkedIn. You'll also be receiving an invite to a survey at the end of today's session. We take that feedback very seriously and would appreciate you filling out that survey. We use that to continuously improve this program and bring you content that's relevant and matters to you. And watch your inbox for an invite to our next webinar on best practices in eDiscovery. And with that, I'll go ahead and wrap things up. Thanks everybody for attending, and have a great day.